If you or a loved one has been charged with a marijuana DUI in the state of California, it is important that you understand the basic procedure of how the case will be handled by the courts. A marijuana DUI case can be broken down into three basic parts. The first step would be the initial contact with law enforcement. The second step would be the lab testing and results. And the third step would be the court process. Let's start off by talking about the first step, the initial contact with law enforcement. The initial contact by law enforcement usually is in the form of a traffic stop, typically for speeding or some other minor traffic violation. Once the officer approaches the vehicle, they will typically observe the visual evidence of marijuana being ingested, or they'll have the odor of marijuana present, and they will observe that. At this point, the officer will start the investigation to ascertain whether or not you are under the influence of marijuana in their opinion. It is important that you cooperate with law enforcement in this initial contact. Once you have provided your proof of registration, your valid insurance card, and your driver's license, you do not need to give any further statements to law enforcement. You have the right to remain silent. Use it. Once the officer starts questioning you about marijuana, when you've smoked marijuana, have you ingested marijuana, you can simply indicate to that officer that any further questioning should be done in the presence of your lawyer. The statements you make or do not make can be the difference, and usually are the difference, between a guilty plea and a dismissal. Once the officer has determined that there is a possible marijuana DUI, and he's already gone through the traffic violation, he will start the investigation into the marijuana DUI. He will ask you questions. Assuming you remain silent, he will ask you to participate in field testing. This process involves visual testing for nystagmus, walk and turn test, balance tests, counting, things of that nature. The problem with these tests are they're unreliable, and they're very rarely indicative of actual drug usage or impairment. However, law enforcement will utilize them as probable cause to arrest you, and later on as evidence of impairment. You are not required to submit to field testing. The officer may, if qualified, or bring an expert who is qualified to start a drug recognition analysis. They will go through a series of tests to determine whether or not they believe you're under the influence of a stimulant or a depressant or any narcotic. Once the officer has gone through the initial questioning about your marijuana usage, has looked at your proof of insurance, your registration, your ID, and has conducted the field testing or not, and gone through the DRE process, they'll make a determination as to whether or not they have probable cause to arrest you for a marijuana DUI. If the officer finds that there is probable cause to make the arrest, at this point, they will arrest you and you will be transported to the station or a hospital for a blood draw to determine the presence of marijuana, more specifically THC. You can find us on the web at Glew Kim Law, GLEWKIMLAW.com. You can reach us by telephone, toll free 1-866-648-0004.